You know, I love how um, this comes clearer and clearer as I move along. But always push forward in intactivism. Again, anti-circumcision activism. Uh, so I always encourage intactivists to file suit themselves, pro se. If you go to an attorney, right away you're going to be spending a lot of money and you're going to be up against the individual egoism. I mean, it's a natural phenomenon, just exists in nature. But and if you have a lot of money, go for it. But find somebody that's, you know, a, a heavy hitter, not some young person that's timid and afraid of getting in trouble. This is the thing about intactivists is, well, I talk to these guys, and some of them have the money. Just budget $1,000 per lawsuit, and that covers both the circuit court level and the appellate court level. All the documentation is ready. It's copy and paste. I have a bunch of it you can use, and, and I'm not against you going to an attorney for consultation. Just don't, just unless you're wealthy. And even then, I don't know that's working. You could get Peter Adler's book, "Circumcision is a Fraud," and just use a bunch of language out of there, or Eric Klopper's and Peter Adler's lawsuit, "How to Check v. Oregon." Get some language out of there. Get some language out of my own. And this is simple. I do not go into the weeds on these lawsuits, and the defendant will always try to drag you into the weeds. I shut that shit down. Anyway, the point is now we have this ample evidence. Uh, there's probably a legal term for. Anyway, that speaks to the manifest injustice. 12 judges, it's probably been 13 because I was walking into one courthouse repeatedly. Um, but kind of officially e-filing civil suits. I've got 12 judges have looked at four suits so far, give or take a judge or two. Four suits are pretty much defunct. The fourth one, I mean, I just sent back a motion for an en banc hearing. I said that yesterday. But, and the fifth suit is just like the fourth one, but I haven't heard back from that appellate court yet. And the sixth suit is at the circuit level still. I talked about that in the last video. So the judges have painted themselves into a corner. And this is what you call manifest destiny. You know, there's nothing they can do about it. This is, how should I say this? This is desertification. It's bigger than uh, a couple of bonehead judges. It's much, much bigger. And now, and the idea here with thousands of intactivists filing suit is that you'll find, I don't know, I'm just going to guess and say 3% of the judges will sign on right away, just right away. Maybe a lot higher, percentage. Um, so anyway, there's no doubt about it. There's manifest destiny. They cannot do anything about it. But we have to continue the desertification process. We have to go forward. Now, when I say arrest a judge or a doctor or a chief of police, a district attorney, a hospital administrator, and people like this, and the crimes are sedition, it's the criminal restraint, aggravated child abuse, it's human trafficking, and this is all with a This is all with a hate crime writer, because you've singled out just one segment of the population and saying everybody else in the country has constitutional rights except this group. That's a bias crime. A bias crime is a hate crime. Okay, so when you go to make this arrest, I'm not talking about a John Brown type thing, attacking Harper's Ferry, the armory or whatever was there. This was when he got tired of hearing all these excuses about why slavery was such a beautiful thing ordained by God in the Bible, et cetera, et cetera. And got tired of all the talking, which is very frustrating in the Intactivism movement. I've seen people, all Intactivists get frustrated about this, but you have to realize that stuff is happening. The movement is growing very fast, and we are starting to move into the courts. But don't depend on other people. Put your name on this. Please, put your name on this. God bless him. The Potts guy, Prevail Over the System, he gets frustrated at the groups, but he doesn't realize that he's waiting on someone who isn't waiting on anyone. They're pushing forward, and you've got to take one step lateral, push it forward, make your path, make your own path. Who was the author? The Pathless Path, or something like that. So don't go all John Brown on somebody. I would take pepper spray and zip ties. Of course, you could lose your life, but what the fuck use are you as things stand? This is why Judaism gave up all of the killing mitzvot. There was like 24 of them, and because it wasn't guaranteed that you were going to be the one that didn't end up, that you weren't the killee instead of the killer. And they were giving up all the harming mitzvot except this one against children, because children can't fight back. There you go. Secret revealed. So you say to somebody when you arrest them, you are under arrest. Turn around and put your hands behind your back. Now, you've seen plenty of YouTubes where the police arrest people, and most people are like, oh shit, okay. You're going straight to the police station. If you're concerned about not being safe, they'll take good care of you. You'll be safe. But if you fight, that's the thing. You might get into a little bit of a Donnybrook, but it's invigorating. It's really invigorating. Now, and then you read them. If they start yapping right away, you say aggravated child abuse, but not just hold on, because you got to read them their Miranda rights. You say you have the right to remain silent. You got to emphasize that. You have the right to remain silent. Anything you say can and will be used against you in a court of law. This is why the appellate courts never want to write an opinion. Never want to write an opinion, because it's just a confession in this context. So you have the right to remain silent. Anything you say can and will be used against you in a court of law. If you cannot afford an attorney, one will be appointed to you. Now, okay, so you got the zip ties on. Boom, they go in the car. You already know where the police station is. Beeline. Drive careful. And then even call 911 and tell them you got one on the way. So now you get there, and they start blathering to the police about how, they've been accosted and all of this. One of the two things are going to happen. They're either going to take them into custody, take you into custody, take you both into custody, or neither. That's 4 things, or neither one of you. But here's the thing about them taking the district attorney charging you. The police might take you in and book you, and then you're good to go before the judge. So they say, well, it's a kidnapping. Well, no, you don't kidnap somebody to take them to the police station. It's a citizen's arrest. Um, this is why there's nothing they can do about it. Now, the district attorney has to decide, what am I going to charge this guy with? And now, he's in the same position that the judges are in who do not write opinions. He has to say, he has to put in writing why you're doing his job. Man. So there you go. Then you get due process. Here's the thing that, and this is the other thing you tell this person that's maybe frightened when you go to arrest them. You get due process. Don't worry about a thing. You get due process. You get an attorney, a free one if you can't afford one, etc. Not only that, will you have due process in criminal court, but you'll where you might be the defendant, no doubt about it, but you'll get it also in civil court, and again, going both ways in that case as well. But you'll get 2 juries of your peers, 2 juries in that case. But you might find that the district attorney refuses to press charges, because, first of all, it is a citizen's arrest, which is a thing. And second of all, because they have to put it in writing. This one in Sarasota, Ed Brodsky, he's saying, well, it's the state attorney has prosecutorial discretion, and it is our policy. This was his defense, his in-house state, in the state attorney's, the attorney general's office. Ouch. They got an in-house defendant for him. I said, you're a public servant. Let's see that policy in writing. Let's see it. Oh, my dog ate it or whatever. You don't ever see it because same thing. That would be a confession. It would not be any kind of a help to them. So that's where we're at. But you push forward day by day. Don't worry about what's going to happen next week. And I don't know why intactivists are afraid of interacting with the court. If you don't have any open warrants, don't worry about it. There's this thing called SLAPP suits. I forget the acronym stands for, but if you're suing them for good cause, these people, the government especially, I forget, look it up, SLAPP. Hang on, let me pause it and let me look it up. Okay. SLAPP is 2 Ps, or strategic lawsuits against public participation, are lawsuits filed by wealthy individuals or corporations to silence critics and prevent public participation on issues of public interest, not to win the case itself. These lawsuits aim to intimidate critics by threatening costly, stressful, and time-consuming legal battles. I think that's what intactivists are afraid of. Thereby chilling free speech and deterring others from speaking out. Many states have enacted anti-SLAPP statutes to provide defendants with legal tools for early dismissal of these meritless cases and to allow for the recovery of attorney's fees. So if you got some do-gooder with money that wants to go that way, there you go. It's there is an anti-SLAPP law in Florida where I am. So, the idea here, the paradigm is not to want to hurt someone. This is another catch-22. We are absolutely trying to prevent people from hurting defenseless children. And so if they don't quit, You know, World War II, who was it leader before Churchill, Chamberlain? He said, Adolf, come on, dude, stop. You know what? You're the prime minister of Germany, and some areas you're doing a really good job bringing everybody out of the doldrums from World War One and the Great Depression, and yada yada yada. And so he wouldn't stop. What do? This is how the Intactivist movement has to think about this. We're not hurting people. You're hurting people, and you have to stop. And so, and like again, like I say, don't take a gun when you go to make these citizens arrests. Just take a can of pepper spray, and maybe a stun gun. And you know, if you cooperate, you're going to go straight to the police station. They'll take good care of you. I'll drive careful on the way there. And you do have a right to remain silent. You know, follow that judge's lead and zip it. Follow the state attorney's lead and zip it. How they've gotten to sedition is a career move. And the other thing was deprivation of rights under the color of law. How did you get to that as a career move? Human trafficking. How did you get to that as a career move? And all with a hate crime writer. How in the hell did you get to that? You poor lost soul. You dumb son of a bitch. All right. So that's where it stands today. I've already started writing for the next hearing. Again, not knowing exactly how it works. Judge Brewer, the second Sarasota hospital case, may also attempt to, you know, silence the matter without any further whatever. But this modus operandi will definitely work. Like I said, it's just manifest destiny. Nothing we can do about it. Nothing anyone can do about it. So yeah. All right. Thanks.